calling 2022 CR 10214B, State of Texas versus Gracie Segundo. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Javier Oliva and Bradley Bellows for the criminal.
Are you Gracie Segundo?
Yes, ma'am.
All right. According to the plea bargaining agreement, punishment is to be assessed at 7 years in the prison. There's a $500 fine.
All right off the bat, the stakes are high. 7 years in prison plus a $500 fine. The state is opposing deferred adjudication, meaning no second chances here, no probation with dismissal later. This sets the tone. The prosecution wants accountability, and the defense is already gearing up to push back hard. Stay tuned, because the battle for deferred adjudication is often where a defendant's future hangs in the balance.
The state is opposing your application for deferred adjudication. They're recommending community supervision, and there are items to be taken in consideration. Have both parties had a chance to review the PSI report?
Yes.
Any objections to the PSI report, state or defense?
Judge, so there are some errors on the PSI report that we wanted to bring to your attention.
Yes.
So it lists the offense date as, I believe, November 16th of 2021, when in reality the offense date that's on the indictment is October 16th of 2021.
All right.
And it lists that in the criminal history. There's an assault that was in the criminal history that it makes it seem as if they're two separate offense dates.
Okay.
And then I think in the, towards the back of the actual statement itself that Ms. Segundo gave, there's a portion where it's talking about the co-defendant and that he's charged with ag assault deadly weapon. It's assault SBI. It's the same offense.
Okay.
We just wanted to make sure you were aware.
All right. And the court is also in receipt of victim impact statement. And the court reviewed that without objections from the state or defense. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
And the court is also
Quick legal note. The PSI report is a critical document here. It's the judge's main tool to understand the defendant's background and offense details. Objections to inaccuracies? That's a red flag. Even small errors can affect sentencing decisions. Both sides are meticulous because every detail counts when she, the judge, decides on punishment or leniency.
in receipt of letters that defense presented on behalf of the accused. And there were no objections to the court reading those letters. Is that correct, state and defense?
No objection, state judge.
All right, so the court has reviewed all of those documents.
Your Honor, I also raised that part of the agreement of coming back today was that the misdemeanor that occurred on the same day of this alleged date was to be taken into consideration with CC County Court 4 case 969-3701.
Yes, and the court does have that as a part of the plea bargaining agreement.
And Judge, just to kind of expand on that, I believe as an additional part of the plea agreement was that she was to take responsibility for what happened as a part of the TIC.
Yes. Okay. All right. So my understanding, the complainant in this case is Rebecca Martinez.
Yes.
All right. And is that the Rebecca Martinez who's on the fourth court?
Yes, Judge.
Yes, sir.
All right.
President of the courtroom.
So that everybody can be aware, I do know Rebecca Martinez. She's never been to dinner at my house. I've never been to dinner at her house, but I do know her. We are colleagues. And when I see her, I say hello. She says hello to me. I may ask her about her day. She may ask me about my day. But I will tell you that my decision on this case is not going to be impacted by the fact that I know her. So if anyone has any objections to me hearing this, now is the time to say so. State?
No, Your Honor.
Defense?
Your Honor, I have all the confidence that it was fair and right in this case. So no objection.
All right. So are there any witnesses that anyone wishes to present? State?
So the state doesn't have any witnesses. The main thing that we wanted the court to be aware of was the statement from the complainant, which the court has already noted that they read.
Yes. Defense, any witnesses?
Your Honor, other than my plea and our arguments to you before considering sentencing in this matter, I will be speaking, and Ms. Segundo may say a couple of words, and Ms. Segundo's parents are present in support of her today. I can stand with Mr. Standing here in support of her today.
All right. Thank you.
They will not be speaking.
Right. So before I begin with your presentation, with regards to the case to be taken in consideration, if you could raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand, state your name for the record.
Gracie Segunda.
All right. And with regards to County Court Cause number 693-701, the state is taking that case into consideration, but to that case, how do you plead?
No contest, sorry. I'm just nervous.
That's okay. So in order for me to take that into consideration, she will have to accept full responsibility for it. So a no contest plea, I can't accept that because I don't have any police reports in regards to that. So she will have to enter a plea of guilty to it and accept responsibility for it. And then the state will tender dismissal to the court and the court will sign that. I don't know if you want to discuss that with her.
We'll go ahead and proceed with a guilty plea, Your Honor.
All right. So the County Court Cause number 693-701, how do you plead to that? All right. And state, do you have the dismissal
Yes,
for the
sir.
court in that cause number?
Here's where things get interesting. The state is opposing deferred adjudication because of the offense's serious nature. Assault with significant victim impact usually makes courts wary of probation-only outcomes. But notice the defense strategy, highlighting the defendant's character references and family responsibilities. This is classic humanizing the defendant to sway the judge emotionally and legally.
All right. So the court then will hear argument. State, you're opposed to deferred adjudication?
Yes, Your Honor. The reason why the state is opposed is because of the nature of the offense, the actual underlying facts. There was an assault that occurred where the resulting assault it created a lot of issues for the complainant. She was severely injured. Her life was severely impacted from that day forward, and she still feels the impact to this day. It's something that was senseless and didn't need to happen in the first place. So that's why the state is opposing deferred and is asking for probation.
Defense?
Your Honor, we're here because one incident can't define a person for the rest of their life. And this is very serious, and no doubt we take that very seriously. This is a felony charge. It's a felony charge that carries a very significant penalty. But Ms. Segundo, I think, has demonstrated a respect not only to others, but to life and to animals and her work and her career and taking care of pets. Rarely do I have an opportunity to where a client will provide 32 letters of reference about how wonderful she is with caring for others. And that is the life that she defines herself with. We just feel like this should not define her as a felon for the rest of her life when she has 4 children as a single mother. We know that life is difficult and it's very, very, very hard. And she's having to raise 4 children on her own, ages 15, 14, 12, and 10. As a single mother, she has to be involved in their school activities and support their activities with FAA. And a felon cannot be associated with children and be around them in school activities. This would drastically impair her ability to be a mother to her children. And so she's really fighting to be able to continue to provide the love and the support of 4 children that need their mother so that they can become better than her and have a future. She lives in Houston. She leases a home. She's lived in that home for 3 years. She has good family support. As I've said, her mother and father are present. She has a high school diploma. She has been employed during this whole time. This case is 2 years old. 2 years this week, this happened. And it's been 2 years that she has been experiencing this, and she has complied with everything this court has asked. She's appeared in court. She's traveled from Houston to San Antonio. She has fully cooperated. She has weighed all of her decisions and sought not to seek a trial, but to put the decision on deciding her future on you. And she made that decision because she felt that was in her best interest. She does receive some child support. She is willing to do everything and anything that it takes to give her this opportunity. I explained to her that deferred adjudication is a double-edged sword. You may think like, okay, you're not going to be subject to conviction, but
Important legal insight here. Deferred adjudication might sound like a get-out-of-jail-free card, but it's a double-edged sword. The defendant still lives under a microscope for years, with strict conditions. Think of it like probation on steroid. If she violates conditions, the original charges and punishments can be reinstated. The defense is making a passionate plea that one moment shouldn't define her lifetime.
in actuality, you are subject to all the conditions and behavior for 7 years. We're asking you, Judge, to give her that chance, to give her the opportunity to prove to you that this one incident does not define her life or who she is or how she is as a mother or how she works. This case was very regrettable, and it should have been a day of celebration. It was after a football game, and she was acting in defense of another. She doesn't know the victim in this case. She doesn't know the judge. She never knew who she was. And I sincerely believe that just because she's a judge doesn't mean that this case should be treated any different than any other case of any other person who comes to this court and gets justice, because she should get an opportunity to do it. She's willing to do the urine analysis. She's willing to state no contact, and she's had no issues in the last 2 years with the defendant, the complainants in this case. She's willing to take anger management classes. She's willing to do community service. She's willing to do what it takes to give her the chance. And she has proven, other than this one incident that happened in a flash, wasn't premeditated, it wasn't thought of. It was just something in a reaction and defense of someone that she was with. And for that reason, we think that she should be given an opportunity to earn the right to be able not to be a convicted felon. The amount of restitution in this case, I think we've agreed to, that was presented before the court, was $2,416.29. We fully agreed to repay that. We will work hard every day to pay that back. But in this working community and in Houston and San Antonio, mothers every day have challenges. And we regret that this happened. And I know that she sincerely had nothing personal against Ms. Martinez or her husband. She wants to do what's right, but she also wants a chance, Judge. And I'm asking you with all the fiber of my body to give her that chance. And I will make sure and work with her that she will comply with every condition, so she will never be back here before you regarding any violation or any condition of this case. You want to say something?
Yes.
All right. Well, just so you know, in this court, I see everybody as a human being. I don't see them as their titles. So for me, defendants are not defendants. They're human beings who are accused of a crime. The fact that Rebecca Martinez is a judge, that doesn't mean that I'm putting weight on the fact that she's a judge. If she were the president of the United States and she were here as a complainant, I wouldn't put weight on the fact that she's the president of the United States. I'm just dealing with the facts here. And my job is to look at everything objectively and not outside noise, not what people's occupations are. You understand? So I always reread everything and reread police reports and the PSI report, and I've read the letters.
Now, listen closely. The judge is zeroing in on the elevator incident details. This is not just about a fight. It's about what sparked it. The judge's skepticism about how an elevator capacity dispute escalated to assault shows a critical legal mindset. She needs a clear, logical chain of events, not vague or confusing stories. The truth has to stand up to her scrutiny.
I do not understand how the fact that an elevator has a limited capacity, how we go from people saying the elevator is full, you cannot be in an elevator, to it's a brawl. So explain that to me.
I mean, it just, I couldn't tell you.
I mean, there has to be some sort of thought process. For example, if there's an elevator, I think everybody knows there's a weight capacity on the elevator. Me personally, when I see there are too many people on the elevator, I don't get on. But obviously what we are here now for is there's an elevator. According to everything that I've read, the elevator was at capacity. And there were already some people on there. I don't understand how an elevator is at capacity. People need to get off or more people can't come on. How that ends up in a fight.
Yeah, I couldn't tell you how it started. I just, somebody in my party was getting into it and somebody hit me and I just reacted. Unfortunately, I feel bad. I should never have done that. Shouldn't have got to that. It just happened really quick.
I know things happen quickly, but the police report I'm reading, it doesn't say that somebody in your party got in an altercation and you got hit and so therefore you got into a fight. What your counsel is telling me is that somebody in your party, I guess, was in a fight and then you decided to get involved in that fight.
I went to go and try and pull my friend away and then I don't know, it was just a bunch of people and somebody hit me and I just reacted.
Your Honor, if I could clarify, I think the facts is this is a COVID era situation in the elevator. These elevators can accommodate 18, 20, 22 people, and they were limiting it to 7. And as people went into the elevator, the policy and procedures of the elevator operator of not allowing people to come in once they met capacity. They were in the elevator. They were asked that there was too many in the elevator. And then people had to decide who's getting off. And they asked who she was with, another man and another person to get off the elevator. That person said, I want to talk to your supervisor. That individual entered into an altercation with the victim's husband that spilled out of the elevator onto the floor. She came in assistance to that man, and that's when she was hit, and that's when she struck the victim. That's stated in one of the reports here that was provided to you in the PSI. And she did not go in there to fight. She didn't go in there to look for someone to fight. She was trying to get someone off of her friend. And in the process of that was struck and she injured Ms. Martinez. And so it's regrettable, Judge. There's no doubt about that. And this incident happened in a matter of seconds. And that's why we're here 2 years later doing that. And in addition to that, Judge, there is a civil suit in this case where the parties in this case are seeking $1 million in damages against my client. And so this case will not end today. It will continue in a civil matter with a lower burden of proof, where she will have to defend herself in a civil cause of action for money damages.
And Judge, just to clarify from the state's end, I would disagree with the characterization of how the incident started. The party was already on the elevator. The complainant's party was already on the elevator. They were asked to not enter the elevator. They weren't kicked off the elevator. They were asked not to enter.
They were in the elevator.
And that's what started it.
And I also have a copy of the lawsuit that was filed this week before the sentencing, where they're seeking $1 million damages in civil lawsuit right here. If you want to see it, Judge, it's public record.
I would object just because relevance.
So lawsuits and filed in the city court, that's a copy from the courthouse.
All right. Unless there are some facts that are listed in the
It pleads
lawsuit.
the whole case, Your Honor. Exactly what you're talking about is pled in the civil suit.
I mean, if that document has facts that somebody has, alleged facts that somebody has presented, that's a different rendition from what's in here, then the court will.
It doesn't, Judge.
All right. So,
just to let you know, there is a civil suit.
all right, then the objection will be sustained. All right. Anything else from either side?
No, Your Honor.
No.
The judge's reflection on sentencing is a textbook example of weighing punishment versus rehabilitation. It's not just about punishing wrongdoing, but also about whether the defendant can be rehabilitated and reintegrated. This moment often reveals the judge's philosophy and can foreshadow her final decision. Notice how she acknowledges the defendant's positive traits but balances that against the offense seriousness.
All right, I've read your letters that were presented, and it appears that, other than this one incident, you're a great person. But sometimes sentencing, well, not sometimes, always sentencing has to do with punishment, rehabilitation, and basically whether or not someone should go to prison or not go to prison. These are all things I have to think about. You understand? And so I have to weigh certain things. And the things that I'm weighing are the fact that there were people in the elevator and you were asked not to get on the elevator. Is that correct or is that not correct?
You were on the elevator.
Your Honor, the elevator's doors open. They entered into the elevator and they were asked, there were too many in the elevator, and the elevator operator asked people to voluntarily get off.
All right, so there were already people on the elevator. Then you got on the elevator and you were asked to get out?
Us just walked in at once.
All right.
And
And then you were asked to leave.
then they said we need people to get on.
All right, so why didn't you just get off the elevator? That's what I don't understand.
You didn't decide that.
Yeah.
She didn't decide that. It was a person that she was with, Your Honor, who is a defendant in the case that's in another court.
So my question is though, if there are too many people on the elevator, and let's say you get on the elevator, it's a group of you, the elevator is already filled. I'm assuming, and correct me if I'm wrong, people were on the elevator, they had not met their 7-person capacity. And then you and your group come on, and because of the number in your group, they've exceeded their 7-person capacity. And then they're saying, you all need to get off the elevator and wait. Why not just get off the elevator? That's what I don't understand. Even if you're with somebody in your party who says, I'm not getting off the elevator, why didn't you just get off and I'll wait for the next elevator? I'll take the stairs. I don't understand.
We had already gotten off 2-4, so we said like you've been waiting, but we didn't want to be the ones to get out.
And was alcohol involved, or people just don't want to take the stairs?
Football game, Judge.
The state, does anybody want to, I know the complainants are here. Do they want to
No,
say anything to the court?
no.
Okay.
Oh, Your Honor, may I have one moment?
Yes.
Your Honor, I'm going to call case Washington.
Okay.
Your Honor, he's not a victim in this case.